Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful and incredible Alex Barthet, a Florida construction lien law expert. Today's webinar topic is, I recorded my lien. How do I get paid? So without further ado, I'd like to introduce the fabulous Alex Barthet.
Thanks, Jesse. My name is Alex Barthet. I am a board-certified construction attorney here in Florida. And today we're going to talk about what you need to do to get paid after you record your lien, because a lot of people believe incorrectly that once you record a lien, then people are going to pay you automatically. And unfortunately, that's not the case. So today we're going to talk about how to make that happen. So if you have any questions during the presentation, feel free to put those questions in the GoToWebinar chat box. We will answer all the questions at the end. Please do not include the names of any people or companies in your question. All right, so what's on deck today? Number one, we're going to talk about what a lien is and how it works. Next, we'll talk about what happens after you record a lien. Then we'll talk about some ways to get paid. And then we'll run through a few scenarios that you may run into after you record a lien, such as someone bonding off your lien, if you receive a notice of contest of lien, or a 20-day summons. We'll talk about what each of those are and how to deal with them. And of course, if you have any questions, you can submit them and we will answer them at the end. All right, so let's get right into it. So what is a lien? So a lien is an encumbrance on real property. It prevents someone from selling the property or refinancing the property because it creates a cloud on the title. Now, it doesn't stop someone from transferring the property, but you still have your interest in the property. So let me give you an example. If I owned a piece of property and you were a painter and you came and painted my house and I didn't pay you and you recorded a lien, I could prepare a quitclaim deed or a warranty deed or any type of deed for my sister, and I could sell the property to my sister and I could sign a deed and she would be the owner, but your lien doesn't go away. So don't think that just because someone transfers the property out from under you when you have a lien that you lose your lien rights. That's not the way it works. The reason that people say that it prevents a sale or prevents a refinancing is because in a normal arm's length transaction with a bank as for a refinance, or with a closing agent and a regular arm's length transaction buyer, they're going to run the title. When they see the lien, they're not going to allow the title to transfer because that title is that lien is a cloud on the title, and therefore that's what prevents the sale. Because the title agent and the closing attorney and the real estate agent, they're not going to let the sale occur because of the lien. So a lien is also a technical default on most mortgages. If you read a mortgage, you'll notice that it says that you as the owner will prevent any liens from being on or remaining on the property. Now, a lien by itself usually will not cause a lender to foreclose on their lien, but sometimes you may have a lender who gets upset that the owner of the property has allowed a lien to be put on the property. So that may create a little additional pressure for the owner of the property if you put a lien on. Again, it probably is a violation of the mortgage, but it's not going to cause the mortgage to go into default just because the lien is there. If you are a sub or a supplier and you put a lien on a piece of property where there's a GC, that prime contract probably has a provision in it that says that your lien as a sub or a supplier is a default under the prime contract. So understand that putting a lien on a piece of property that is under construction where you are a sub or supplier, that's going to create a lot of headaches for the owner and the prime contractor, and they'll probably want to try to resolve it. Hopefully resolution means paying you, but that lien creates a potential default for the prime contractor within their relationship with the owner. And obviously on jobs that have construction loans, that lien, when the construction lender runs title, which they typically do every month or every other month, that lien is going to show up, and that lien is going to prevent the lender from funding. So the lender is going to say, hey, there's a $30,000 lien on the property. We're not funding this next $400,000 pay request until that lien gets taken care of. So understand that the lien is a very powerful tool, and when used in certain scenarios, it has it can bring a great deal of pressure to bear and cause you to get paid. Let's go over some basic notice to owner and lien rules. It's always a good thing for everyone to understand. I still talk to people in the construction industry. I've been doing this for 25 years. I still run into people that don't understand what the lien rules are. So I always find it's very helpful to run through them so everyone knows. If you are a sub or a supplier on a project, you need to serve a notice to owner no later than 45 days from your first work of delivery of materials or work to the site. That's step one in order to have any lien rights. Within 90 days of your last work, or delivery of materials to the site, you need to record that claim of lien with the clerk in the county where the property is located. By the way, 45 days and 90 days are every calendar day. It's not just business days. The way you count them is you start by, if today was my last day of work, tomorrow is day one. I count every single day, weekends and legal holidays, all the way through day 90. And if day 90 happens to land on a weekend or legal holiday, then it rolls to the next business day. The next step is that you have to file a lawsuit in court no later than 1 year from the recording date of the claim of lien. This is the absolute outside deadline to keep your lien alive. There is no such thing as re-recording the lien. I hear people say, oh, my lien is coming up on the year, I'm just going to record another one. Nope, that's not the way it works. Your first lien will be expired if you don't file the lawsuit. And if you re-record another lien, that new lien is now a fraudulent lien on the project. Now, there are lots of exceptions to these rules. This is just the basics. So just be aware of that. But you need to at least at a minimum understand these time frames: 45 days, 90 days, and 1 year. Now, we have a great tool. It's called where'd it go? It's called the Lien-O-Matic. You can go to www.lienomatic.com and we will send you one for free. It is a handy desk tool that outlines all of the various things you need to record and file and serve to preserve your lien rights, whether you're a contractor, a sub, an architect, a supplier to a subcontractor. And we also have it in the same device. We have it for private projects, bonded projects, public projects, FDOT projects, Miller Act, federal projects. So it's a great tool to have on your desk. Sometimes you may wonder, well, what do I have to do to preserve my lien rights? Or does this person have lien rights? They say they do. You can easily find all the things that you need to file and when you need to file them to preserve those rights. So get it free at lienomatic.com. Okay, so what happens after you record your lien? Unfortunately, nothing happens. You will record that document, it will go into the public record, and nothing else is going to happen on its own. You need to be the one to take the next steps. Now, unless that lien on its own bothers the owner or the contractor or the lender, again, in the examples we talked about earlier, again, I cannot stress this enough, the lien by itself will just sit there. So if you were the painter in my example and you recorded a lien on my house or my commercial building and it didn't bother my lender, and I didn't have a lender and I'm not selling the property, that lien just sits there. And if you don't do something within that 1 year, then the lien will go away. So it is incumbent upon you, if you want to get paid, to do something after you record the lien. So the question is, how do you get paid? And as I said, the lien is only the beginning of the process. It secures your right to be paid. It is the encumbrance on the real property, so that if you go through the legal process, that you have at least some asset you can make a claim against. So it is up to you to enforce your rights through a foreclosure lawsuit in court. Now, this foreclosure case is just like any others. So, it's going to cost money. It's going to take some time. It's not automatic. It doesn't happen overnight. And you will have to prove your case if the other side wants to defend. So what are some of the best steps that I can recommend that you undertake to get paid and get paid faster? So I like to call it the 60-60 rule. What does that mean? I recommend that no later than 60 days from your last work, you start the recording process of your lien. I'm not saying you have to record it on day 60. And by the way, you can record it on day 4. You could record it while you're doing work on the project. You don't have to be done. You can record a lien while you are working on the project. But no later than 60 days from your last work, you need to start the process of putting the paperwork together and recording the lien on the property. The reason is it gives you ample time. We have clients that call us. I know SunRay prepares liens, so they get these calls too. It's day 89. I've got to record this $200,000 lien, and everyone's running around with their hair on fire. It's unnecessary to wait that long and go through that process. Start the process of recording your lien on day 60. It'll give you ample time to put the paperwork together, sign the lien, get it to recording. It'll account for any mailing delays. Someone's on vacation. It takes a little longer here. It takes a little longer there. And then you can do it with a sense of calm. Know that if you record the lien and someone pays you, you can always satisfy it. Rather than waiting and waiting and waiting to the last minute, you never get the check, and now we're all scrambling to try to get this lien recorded on time. So that's the first 60 of the 60-60 rule. Then next, for the next 60 days after you record your lien, hassle your customer for payment. Phone calls, emails, go visit them. Our most successful clients at collections are bulldogs when it comes to their collections after their lien. They don't record the lien and then just wait to get paid. They record the lien, they make phone calls, they send emails, they agree to take partial payments. They work hard to get as much money as they can for the next month or two after they record the lien. But if you haven't been able to get paid for 60 days after you've recorded the lien, my advice is not to wait for the year. You should start the process. You should start the process of foreclosing on the lien sooner rather than later. So hire a construction lawyer, start the process to foreclose the lien, because if they haven't paid you in 2 months after you've recorded the lien, and remember, you've recorded the lien now likely 2 months after you finished work. So it's already been close to 4 months since you've been off this job and you still haven't been paid. Now, there may be business reasons that you want to wait. Aside from those business reasons, I, again, recommend that you don't delay. Maybe your project manager, who's the great witness for this case, they leave, records get lost, people's memories fades. There's really no good reason to say, well, let's wait until month 11 and a half to file the lawsuit versus at month 2. So that's my advice after doing this for many, many years on what are our more successful cases at getting paid. Those are when we bring the claim sooner. So let's talk about some of the things that you may run into once you record the lien. So someone may tell you, oh, you know what, go ahead and record your lien, or you've recorded the lien, we're going to bond it off. My suggestion is tell them, thank you very much. I really appreciate that. That makes my life much easier. Let me explain why. When you record a lien on a piece of property, your lien allows you to sell the property, and what you get from the sale is typically the equity in the property. So let's go back to my example of my house, right? So let's say I have a house, it's worth $300,000. You record a lien for $50,000 and I have no mortgage. Well, that's great. So now there's plenty of equity in the property. And if there's a foreclosure sale and my property is sold, there will almost certainly be a bidder that will show up to buy my house for in excess of your lien amount. Now let's take another example. Let's assume that my house is worth 300, your lien is 50, but I have a $295,000 mortgage on my house. I don't really have any equity. So when we go to the public sale for the property, no one's really going to want to bid, because they know that when they take the property in the foreclosure sale on your lien, they're still going to have to deal with the mortgage. Well, so why are they going to pay $50,000 to buy the property at the foreclosure sale? Because if they pay the 50, you'll get the 50. They won't, because they know they're still going to have to deal with a $295,000 mortgage on a $300,000 piece of property. So there's no equity. Now your lien is on the property, but there's no equity. So if you go through all the way to the foreclosure sale, you may not collect anything. So bonding off the lien transfers the lien from the property to a security instrument, and that security instrument is a bond or cash, and it is equal to roughly 150% of the claim of lien. Let's go back to my example. My lien is worth $50,000, or the lien is on the property is $50,000. If I wanted to bond that off, I need to go to the clerk, or I have to go get a bond for $75,000. So now I go to the clerk, I take $75,000 cash, I give it to the clerk. The clerk is going to now issue this bond and send you a notice that says your lien is no longer on the property, it's on this cash or the surety bond for $75,000. Now you don't have to worry whether or not anyone shows up at the foreclosure sale, whether there's any equity in the property, because your lien is now secured not with the property, but with cash, real money that if you win your case, it will get liquidated and that money will go to you. So again, if someone tells you that they're going to bond off your lien, tell them, thank you very much, I really appreciate that. The only downside I would suggest is that if someone tells you they're going to bond off your lien, or they do in fact bond off your lien, you need to be prepared for a fight. They're not, rather than pay you, they've decided to go through the time, effort, and expense of bonding off your lien. So if we go back and we talk about our 60-60 rule, if you record the lien and you immediately get a notice of bond because your lien was bonded off, I would say there's no sense trying to collect anymore. You should immediately send it to a lawyer. So our advice to clients is, when someone bonds off your lien, just send us the file, or hire your construction lawyer, because they don't want to pay you. That's why they put the lien on. That's why they bonded off your lien. So you might as well start the foreclosure process. All right, so we got two more to cover before we get to questions. What is a notice of contest of lien? You remember I told you that you needed to file your lawsuit to foreclose no later than 1 year from the recording date of the claim of lien. That's the rule. Well, someone can file a document with the clerk, a copy of which is sent to you, and now that 1 year is reduced to 60 days. So if the clerk mails this notice of contest to you, and you, upon the clerk mailing it, not even you receiving it, but upon them mailing it, the 60-day clock starts to run. So what do you have to do? You have to file your lawsuit to foreclose on that claim of lien no later than 60 days from when the clerk recorded that notice of contest. If you file your lawsuit on the 61st day, you lose your lien rights. So your lien will have expired. So if you get a notice of contest of lien, you need to immediately retain legal counsel and start that foreclosure process. Now, the 20-day summons, which is the next item we're going to talk about, is effectively the same thing. The difference is, now instead of reducing it to 60 days, the other side has decided to reduce it down to 20 days. Now, the 60-day notice is a notice you're going to get via certified mail. The 20-day notice, the 20-day summons actually, is going to be served upon you by a process server. You're actually going to be named as a defendant in a lawsuit. Normally, there are rules of the court that allow you to get more than 20 days, but unfortunately, if you get served with a 20-day summons to show cause with respect to your lien, you need to file either a counterclaim or a separate action to foreclose on your claim of lien within those 20 days. If you don't do it within the 20 days, your lien is automatically extinguished. So again, if you get any document like this, the 60-day notice in the mail, certified mail, or a 20-day summons, you need to act promptly and retain legal counsel. We had I'll end with a story. We had a client, he was an electrician. He came to me because he was unhappy with his current legal representation. And it turns out that he hired a lawyer upon receipt of a 20-day summons to show cause. Well, unfortunately, the lawyer that he hired was not a construction lawyer and didn't understand the significance that he had to file this lawsuit within 20 days. So upon receipt of the 20-day summons, this other lawyer, asked for more time, and then ultimately did file his counterclaim, but it was after the 20 days, and the other side filed a motion with the court to invalidate his lien. That's when, unfortunately, we got brought in, and I had to tell the client the bad news that his prior lawyer filed the wrong paperwork and lost his lien rights. That lien was for $250,000, and there was really nothing we could do to prevent that lien from being invalidated because they didn't understand the significance of the 20-day summons to show cause. So don't delay when you get any type of legal notice, whether it's certified mail or handed to you by the process server or the sheriff. So with that, we are done. Jesse, do we have any questions?
Well, first of all, thank you so much, Alex. That was very informative. I really do appreciate it. Yes, we do have a couple of questions that came in. This first one, it says, if I can't include attorney's fees and filing fees in the cost of my lien, if I have to file a foreclosure suit, can I include those fees then, or does it have to be in my contract?
So it should always be in your contract. That's just kind of general good advice. Under the lien statute, 713.29, you are entitled to recover your legal fees if you bring an action to foreclose on your lien and you prevail. So what we do when we prepare liens is we don't list the fees or the cost to prepare the lien. We just say a principal amount of X, and then we just say plus interest and legal fees. We don't list out the amount in the lien. But then when we pursue a lien legally, we demand it from the other side. So that's a long way of saying, yes, you are entitled to recover your legal fees once you start the legal process of foreclosing on your lien. The lien statute gives you that right, 713.29, if you wanted to know.
Okay, perfect. Thank you. And then this one is just touching on what you just kind of went over. On the 60-day contested lien or the 20-day summons, is that 60 or 20 days from the date you received that notice or from the date that the lien was recorded?
Okay, so each one is different. So let's talk about each one in turn. The 60-day notice of contest of lien. The 60 days starts to run when the clerk stamps and certifies it as being mailed out. Not the day you receive it, it's the day the clerk stamps it. So when you receive it, it will have a stamp on it with a date. That is the date that starts the 60 days. So if that date, if you receive it 5 days after that date it stamps, because it took 5 days to get to you, you now have 55 days left. So that is the notice, the 60-day notice of contest of lien. The 20-day summons works the other way. Because it is a lawsuit, the 20 days starts to run once you are served with the legal paperwork by the sheriff or a process server. Know that service upon you, if you are a business, could be a service on your registered agent. So it doesn't have to be physically to you. So if you are a business and you're the one that recorded the lien, your business will be named. If you have a registered agent like a lawyer or an accountant or a registered agent service, it's the day they get served that starts the 20 days. If you are an individual, they can serve you at home, whether that's your spouse or your children that are over the age of 15, they can serve it upon them, and that's when it starts. So for the 20-day summons, it's when it's physically served, but just know that that service may not be on you specifically.
Okay. And then another question says, if we received a letter from their owner's lawyer, is that considered being served the 60 days?
No. That was an easy.
Perfect. Thank you. Yep, it was. And then this one, I know we've gone over it, but I'll let you go ahead and answer this appropriately. So, can I include future work on my lien?
No, absolutely not. That's a big no-no. Your lien amount should only include the value of the materials and work that has been incorporated into the project. It should not include any amounts for materials that haven't been delivered or installed, for work that still needs to be done. So for example, sometimes we're asked to prepare a lien and the client says, well, I'm done. And we say, well, are you really done? Well, I got like a little bit left to do. So what's a little bit? Like $1,000. So then we'll reduce the lien by $1,000. Instead of leaning for 100,000, we'll lien for 99 because there's still a little bit more left to do. So it's better to err on the side of caution in preparing and recording a lien to avoid having someone find that your lien is fraudulent, because there are severe penalties if your lien is fraudulent. I'll give you an example. We prepared a lien for a marine contractor just recently. He had an agreement with the contractor, so he was a sub. My client was a marine subcontractor. So our client submitted about $100,000 worth of change orders that were never signed and approved for extra time that the barge and crane were sitting there. That amount was never signed and approved. We decided to remove that from the lien. So we liened for $500,000 instead of $600,000. We left out that amount for unsigned change orders. Now, we did ultimately file a lawsuit to foreclose on the lien, and we sued the owner on the lien for the $500,000. But when we sued the contractor, who we have a contract with, which is again separate and apart from the lien, we sued the contractor for the $600,000. So it's not that I'm saying, well, if it's not in your lien, then you can never get it. It's just that you need to be conservative in how you approach the amount in your lien and then pursue the other amounts via other legal remedies.
Okay, wonderful. Another question that came in, I'm not sure if you're going to be able to answer it or not. It might be better for them to contact you directly, but it says, what is the average cost to file the foreclosure and process from start to finish for the legal fee and court cost?
So I will answer this question because I get this question a lot. So the amount, the time and effort and expense associated with preparing a lawsuit, filing it, and getting the ultimate foreclosure and getting a client paid depends almost exclusively on the reasonableness or unreasonableness of the other side and their lawyer in dealing with the problem. So when I talk to clients, I spend, quite frankly, most of my time trying to understand the relationship and how that relationship may have broken down between my client or potential client and the other side, rather than all the details about, was the work done? Do you have all the work tickets? I ask those questions, but I assume for the most part that if someone comes to me and says they're owed $100,000, that they have the backup to support the fact that they're owed $100,000. The real question is the other side being reasonable or unreasonable? A legal court case can take a long time if the other side is unreasonable and doesn't want to pay you. other cases, we can file and get settled and resolved in a month or two. So what I usually tell clients is I give them a range because it really depends on what the other side is going to do. So on average, you're looking at anywhere from $2,000 to $3,000, give or take, to prepare the lawsuit, file it with the court, pay the filing fee, pay the process server, and start the legal process. Again, these are just ballpark numbers. Most cases that we have settle typically within 2 to 4 months. It's likely that in that time the client is going to spend several thousands of dollars. But if the case is heavily contested and it goes on past that, or if it's contested in that period, you could spend tens of thousands of dollars in legal fees. Again, the real answer to that question is unknown, because until we know what the other side is going to do, it's very hard to predict how much everything will cost.
Okay, well, thank you. Another a follow-up question just came in for that. And those fees and costs are recoverable per law by the past debtor. Who pays the cost after we pay, I guess, that initial fee or that fee?
Right, I understand. So as I mentioned previously, you have the right to recover legal fees. If you record a lien, the winner has the right to recover legal fees. So if you lose, you may have to pay the other side their fees. But if you win, you can recover your legal fees. But the ultimate determination of who's the winner, if you get your fees, and how much of those fees you get is with the judge. So is it possible that you could win and the judge says, I don't think you're going to get any fees? The answer is yes. That's not usually likely. The more likely scenario is if you win, the judge may say, I don't think you should get all your fees. I'm going to give you 70% of your fees, or 90% of your fees, or 50% of your fees. But again, we can't guarantee that you'll win, and we can't guarantee that the judge is going to give you all the fees that you want. On top of that, by the way, we talked about the fact that you can get fees from the lien statute. You can also recover fees under your contract, but you need to have a written agreement, and that written agreement needs to say that the winner gets their fees.
Okay, wonderful. And then there is one more follow-up question, but this really just you need to reach out to Alex for specifics on this. It just says, do you provide representation outside of your home market?
Outside of my what?
Your home market, so I guess your local area.
Yeah, so we are lawyers in the state of Florida, so we handle cases throughout the state of Florida. Outside of Florida, we are not licensed, but for the most part,
okay.
We can do anything in the state of Florida. All right, so let me move forward on the slides for you, Jesse. Okay.
Thank you. All right, so here are some of SunRay's resources to help you guys stay organized, know your deadlines, and secure those lien rights. So go ahead and scan that QR code to access these incredible resources. There's deadline calculators, there's the state lien law rules. Remember, each state has its own unique lien laws and deadlines, so please check that out. Like Alex said, he is representing the state of Florida, but if you are working outside of Florida, check it out on our site, because each of these states are completely different, and we don't want you to miss any of your deadlines. All right, can you go to the next slide for me, please? All right, so if you don't mind, give us a moment of your time, give us some feedback, scan that QR code. We really do love your feedback. It helps us get more content out about the topics that you're looking for, and it helps get this information to other contractors and suppliers like yourselves. So we really do appreciate it. And then the next slide, if you don't mind. And with that, that is all we have for you guys today. I hope you all enjoyed the webinar. We hope to see you guys at the next one. Thank you again, Alex. You really are wonderful. I hope everybody has a beautiful and wonderful sunny day. Thanks, everyone.